Case numbers 109836 and 111126 in the matter of Miriam Rittmaster.
May it please the Court, Stan Hazlitt, appearing for the Disciplinary Administrator's Office. I would request reservation of 2 minutes, Your Honor.
2 minutes is granted.
We're here today as a result of 2 different hearings on 2 different complaints and kind of a unique procedural history, and I'll explain that as well as I can. There was a disciplinary hearing on the first complaint, which occurred on March 7th of 2013. It's 11,555. The respondent appeared in person with counsel John Ambrosio at that hearing. Mr. Ambrosio was retained shortly before that hearing and actually filed an answer on behalf of the respondent on March 6th. The case arose out of the respondent's representation of the complainant in that case in a divorce action, and the panel found violations of diligence, communication, general misconduct under 8.4C, and Supreme Court Rule 207 because of a lack of cooperation. That day, before the hearing panel, the respondent candidly admitted that she was not emotionally fit to continue the practice of law. Mr. Ambrosio and I filed a joint motion with this court requesting that she be temporarily suspended. And as a result of the filing of that motion on April 1st of 2013, this court temporarily suspended the respondent from the practice of law, and she's remained on that status since that time. That case was then docketed before this court and given a case setting of October 21st of 2013. Just 2 weeks after the March 7th hearing, on March 21st of 2013, we received a second complaint that was filed against the respondent in our office. We docketed it for investigation. It was investigated. The respondent basically admitted that there was misconduct in that case. She cooperated in the investigation of that case. And on September 26th of 2013, the respondent and respondent's counsel were advised that there had been a finding of probable cause in that second case as well, DA 11,793. Mr. Ambrosio and I then agreed at that time to file a motion to continue the case, which was set before this court on October 21st, thinking that you would like to know what happened in the second case before deciding how to dispose of both of those cases. So a joint motion for continuance was filed by respondent's counsel, and our office. That motion, that request for a continuance was granted. The second hearing, disciplinary hearing, was held on January 8th of 2014. The respondent was again present with counsel, Mr. Ambrosio. Again, the complaint in that case arose out of a divorce case where the respondent represented the complainant. She was retained to attempt to set aside a divorce decree that had been entered. The panel found violations of diligence, communication, termination of representation, and the general misconduct rule 8.4D. After the second hearing, both the panel and our office recommended a 1-year suspension made retroactive to the date where the respondent was temporarily suspended by this court, which was April 1st of 2013. To be followed by a reinstatement hearing under Supreme Court Rule 219. At the hearing, the respondent, through counsel, agreed with this recommendation. As I stand here today, my recommendation remains a 1-year suspension, retroactive to the April 1st, 2013 temporary suspension. A reinstatement hearing, I would request that the court require a reinstatement hearing under Supreme Court Rule 219. In both cases, client protection claims were made by the complainants, and in both cases, the Client Protection Commission paid out $1,500. So there is $3,000 that's owed to the Client Protection Commission. In both instances, the Client Protection Commission determined that this was in the form of an unearned retainer in both instances. So part of my recommendation would be, and part of the panel's recommendation, is that the respondent be required before readmission to pay that $3,000 back to the Client Protection Commission. If this recommendation is accepted by the court and the court decides it's appropriate, that would make the respondent eligible to apply for reinstatement upon the issuing of your opinion. I feel pretty strongly that a reinstatement hearing is necessary. When you read the record and look at the exhibits, there was evidence of depression, adult attention deficit disorder. There's a recommendation. There's a letter from dated December of 2013 from the psychiatrist or psychologist who had seen the respondent that she's doing pretty well, and there are records of all her visits clear back to May of 2013, where you can see that she's definitely making progress.
I'm sorry, Mr. Haslett, that letter was December 2013, you said?
Late December of 2013, okay. The letter from her psychologist. But I think that's an issue from our perspective that a reinstatement panel needs to look at, hear testimony from a professional so that you can look at that before deciding whether reinstatement is appropriate. I will say that, and it's mentioned in the second panel report because the one panel member was the same in both panels. He commented on how remarkable the change was in the respondent from the first hearing to the second hearing, and it was readily observable. I mean, she was in much better shape the second time around than the first time. I mean, you could see that she made great strides. And from talking to her today, you can see that has occurred as well. And I would say one last thing. I think, most of the time when KLAP is dealing with a respondent, we don't know about it because they can't tell us, and that's the way it should be. But there are some times when the respondent consents or wants us to know about the fact that the respondent is doing a good job with KLAP. We do know about it. And I know that KLAP in this case was responsible, I think, for getting her to come to the first hearing because I don't believe she was going to come, but for their intervention. And it's just an example. I think they deserve a lot of praise for what they did in this particular case.
Counsel, can you help me with the chronology here? Let's say that we agree with your recommendation. We get an opinion released tomorrow morning that agrees with you. She's then immediately eligible to seek reinstatement of her license and start practicing. How long would that take for the panel to be appointed to convene, issue an opinion on a case like this? Well, I think we would have to do a little investigation to see what's happened in the interim. But I think that we would be talking about 4 or 5 months before we would actually have the hearing set. So from when she was temporarily suspended till now, we're at 13 months, really, like today. So we would be at 1.5 years when probably a reinstatement hearing could be held. And we hear a lot of these cases, unfortunately, but I can't recall too many occasions in which you basically asked us to say, under circumstances like this, to allow her to be immediately eligible to apply for reinstatement. It sounds a little bit like full credit for time served and let's get on with it. So what about this case leads you to that recommendation? Well, it's such an unusual case anyway that it's not very often that a respondent is willing to acknowledge that they are not fit to practice law emotionally and would say to a panel back in March of 2013, I can't practice, and I would agree to a joint motion for agreeing to temporary suspension. So that happened way back then. So she's had this long where she's actually been suspended, as opposed to a normal case where you wouldn't suspend them until 30 days from when we're standing before you today. So it's just, I mean, I don't remember a case like this where it happened like this. And then so many unusual things. I mean, we go through the first case and we think we know where we stand, but then 2 weeks later after the hearing, we receive a second complaint, which the respondent acknowledged pretty much right out of the chute that was meritorious. So it's just an unusual case. Credit for time served probably is a good analogy. And in your view, what would she need to show the panel in the 219 hearing so they would recommend you're in good shape, go back to practicing law? Well, the normal stuff, paying the costs of the disciplinary case, paying the client protection fund, but I just think, it's clear from the record, and their exhibits are in the record. I mean, stuff that I haven't seen before in other cases where there are notes from her various counseling sessions where you can kind of see the progress that she's making. I think it's always important to have a professional, a psychologist or a psychiatrist who would be there, actually be at the hearing to explain why. Because the recommendation in that December, I think it's 31st letter, but it's 2013, is that he thinks, or the professional thinks that at that time she's fit to come back into the practice of law, that she's doing that well. But I still think, given what happened in these cases, that a panel needs to hear that sort of testimony and evidence.
All right, thank you. Do we have any further questions? Thank you.
Thank you.
John Ambrosio on behalf of the respondent. Mr. Chief Justice, Your Honors, the facts and violations described by Mr. Hazlitt are absolutely correct, and the facts and violations talked about in both panel reports are absolutely correct. The amazing thing is the change. At the first hearing, my client could not sit at the counsel table with me without a KLAP volunteer. She could not have made it through the hearing, and I think Mr. Hazlitt is absolutely correct. She would not have been there because of her depression and undiagnosed attention deficit, adult attention deficit disorder at that time had not been diagnosed. Mr. Art Palmer, who was the panel member, who was the chief of that panel, said, should you be practicing law? And he generally addressed that to counsel and to the respondent. And my client, to her credit, said, no, I shouldn't be. And at his suggestion, we then filed our application with the court, which you agreed to, and she has not been practicing law since that date. The progression or the progress that this woman has made from the first day in my office, which was a week before the hearing, to the present day is unbelievable. In both panel reports, the panel indicated that the emotional problems were significant and had adverse effect on her ability to represent her clients. The second panel said the emotional problems contributed to the rules violation. There's not a doubt. After psychotherapy, after antidepressant medication, she got better. But then suddenly somebody found out that she had this anxiety or disorder, adult deficit disorder. And my client will tell you that she called me and said to me, John, suddenly I understand what's wrong with me. I've been practicing law and I've been living my life for all these years, and it was always like I was in a room that had 20 TVs. Now that I've been on this medication for 4 or 5 weeks, now I have one task, I hear only one TV. And she quoted that when she was on the witness stand at the second hearing. The change has been utterly amazing. But she will tell you today, the respondent, she is not ready to practice law. And I agree with the recommendation of the panel. I agree with the recommendation of the disciplinary administrator's office. She's not ready, and she will tell you that because it's an ongoing process. Ongoing process deciding what she wants to do. It's an ongoing process to deal with the depression. It's really an ongoing process to deal with this anxiety that she has and the adult deficit hyperactive disorder. When she is ready, she will apply. I can tell you, I believe she will tell you today because she's told me she's not ready. It may be 6 months, it may be a year, it may be longer. She will make that decision when she feels she is able to do so, to become a lawyer in an effective way and to represent her clients in an effective way.
Counsel,
I'm sorry.
no, what was the nature of her practice when she was practicing? What were the circumstances of practicing? Was she office sharing, in with a firm? I mean, what was going on?
No, Your Honor. She was, as I remember, she was a solo practitioner. She worked out of one office without any secretarial help for the most time. I think early in her practice she had some, but at this time she had no assistant, no paralegal, no one. She was not sharing office space with anyone. And the type of practice she had was some criminal, but also a ton of family law, which is the death knell for anybody who has depression and all the problems she has. And she did some other work, but very, very little. In talking to my client the other day, I don't think she cares that I'm going to tell you this. She told me, John,
Counsel, are you sure you want to be telling us what your client
absolutely,
told
I
you?
have permission of my client to do
All right.
this. I always get permission of my client before I tell you that, Your Honor.
I think that'd be helpful to tell us each time.
Okay, I will tell you each time. I never violate client confidences. She told me a couple of days ago, she said, John, if a big law firm in Kansas City offered me $2 million to do domestic work, I wouldn't do it. I think that's telling. I think that shows me that she's on the way to recovery. I think that should show the court that she is working her program. And I urge you to follow the recommendation of the panel and Mr. Hazlitt. My client would now like to talk to
Mr.
you.
Ambrosio, can I just ask a quick
Certainly.
question? You mentioned that your client doesn't feel quite ready yet to return to practice, and I'm sure that she'll visit with us about that as well. But does that mean that even though you are urging us to follow the panel and the disciplinary administrator's recommendation of 1 year retroactive to her temporary suspension date, that you don't anticipate that she'll file an application for reinstatement immediately?
Your Honor, that's absolutely correct.
Okay, I just want to make sure I was reading that right.
Thank you, and I think she should tell you that too.
Thanks.
Sorry. My notes are all just, okay. Miriam Rittmaster, your honors, there are not words to describe where I was when I first met Mr. Ambrosio. I was literally curled up on the couch. I had not answered the phone in 2 weeks. Every morning when I got up in the morning, I started counting the hours till I could go back to bed. I was contemplating suicide because I just couldn't stand it anymore. Then I don't know why I answered the phone, but I did. And Carol Bonebrake was on the other line, and she and I had a long talk, and she said, this is 3 days before the hearing. And she had me come up to her office, and we talked. And she brought me over to Mr. Ambrosio's office, and he graciously agreed to help me out. But that was just the beginning. I'd always been treated for anxiety and depression, and I've learned since then that that is the standard go-to for doctors, because it's been a very short time where adults get diagnosed with ADD or ADHD, and anxiety and depression is a byproduct of that. So I was getting treated for anxiety and depression, and because I was taking medication, I thought, well, there's nothing more that can be done, which is why I didn't seek help before. But now I know that there is help, and I was hitting rock bottom. And it was not only that, I had serious issues with my kids. My son has severe ADHD that requires intensive intervention. I was getting a call every day from his kindergarten teacher to strategize how to best keep him in class, in a regular class. And my daughter, who was, 7 or 8, was also having suicidal ideations, which is, excuse my language, scared the crap out of me. And I was dealing with her and her therapists, and she's also got medical issues. She's got asthma and eosinophilic esophagitis. The first day of the hearing, Carol literally had to take my arm and pull me into the room. I wasn't sure how I could safely drive home, actually. And I sat there for a while after the hearing because I just couldn't concentrate. But Mr. Ambrosio and Carol gave me a list of things to do, and if I have a list, I can do it, and I can check them off. And I went to a psychiatrist. It took me several months to find one that would be on our plan, because insurance companies, and I wanted somebody that would be a good fit, but that would also be in my insurance plan. And she was fabulous. and she talked to me and she adjusted my medication a bit and she gave me the name of a therapist. I immediately made an appointment with the therapist, and after the second meeting, he said, I want to test you. And I said, okay, fine. It never occurred to me that I could have ADD, and it turns out I did. And he called the psychiatrist who gave me a prescription, and when I got home, I cried. I said to my husband, is this how normal people think? I could complete a task. I could go from point A to point B and not, stop in the middle, which was what I had always done. And I will remember at Science City that weekend was the first time I was able to watch and enjoy my children without checking without having a dozen other things in my mind. I could focus on my kids. And that was a wonderful feeling. And it gives you the ability, but it doesn't give you the desire. So it's not a magic pill. You have to keep going to the psychologist. You have to keep working your CBT, cognitive behavioral treatment, which is what I'm doing. And I had a slight setback in December, but I immediately called my therapist and got an appointment, which is something I never would have done a year ago. And he helped me through it, and that was, like the first time I'd ever actually reached out. I felt calm. I felt I could get through a day without yelling at my husband. For the first time in forever, because the chemical imbalance in my brain was fixed. I took with taxes, I'd half gotten them done, and it had taken me 3 months to get the first half done on my medication. The last half took 3 hours. And it was amazing. And Mr. Ambrosio is right. It's like having 12 TVs in the room, all tuned to different channels. And you take the medication and it turns off the television and you can focus because you're not trying to hear and absorb a dozen different other things. And again, I was forced to get the help that I needed. So if that's the case, I would do this 1,000 times. Because I could not go on the way I had been, and I wouldn't be here if I did. The resiliency group is fabulous. I hate groups. I try to, Al-Anon, hated it, never went back. I don't like touchy-feely, blah, blah, blah. I'm not that kind of person. But I walked into the resiliency group meeting, and the feeling is indescribable. It's a safe place to be, where you can talk to people and tell them about what's going on and have them help you out, and know that it's never going to be held against you. Nobody is ever going to talk about it. And I go. It's the first and third Thursday, Wednesday of the month, and in the last year, I think I've missed 4 because.
Answer Justice Barr's question about if you're going to apply again. I think that's important.
Okay, yes. I am not ready. I don't feel ready. My doctor may say that I think you're ready, but I don't feel ready. I've got a lot of work to do because prior to the medication, I developed a whole lot of bad coping mechanisms that I need to unlearn. And those types of coping mechanisms were what got me into trouble in the first place. So it's going to take a while because it's not a magic bullet. So I'm working my program, and I'm volunteering. What I'm doing is I actually am working. Have work. I do. I speak at schools about the parent side of having an ADHD kid. which to a lot of teachers is a revelation. I'm also on the board of, on the advisory board of a women's recovery center. What I'm doing is I'm helping them get their office ready to put everything, to electronically put everything in the, in the computer. And I actually also have a part-time job that is going to be a very lucrative job, which lets me be flexible with my kids. And I just want to I accept full responsibility for what I have done. It was horrible, and I deeply, deeply regret it. And I'm telling you all of this not as a justification. I'm telling you this as an explanation. So I just want to thank all of you.
Thank you, counsel. Did we have any questions of either of these attorneys?
I've got one, and it may be better directed to Mr. Ambrosia. I don't care who answers it, but one of my concerns is always in these orders, if we follow the recommendation of the disciplinary administrator, we're going to say have a reinstatement hearing, and one of my concerns is always that just doesn't have any definition to it, and sometimes I feel like we need to point the reinstatement hearing to certain issues. So I guess my question is, what does reentry to the practice of law look like for you, for as far as a structure? Does it need to be supervised coming back in? Do we need to put something in an order if we accept the recommendation that says something about supervision, those kinds of things, or even other kinds of counseling or anything else? I'm just trying to figure out what ought to be in the order to help this look like a successful plan of reentry.
Number one, she needs KLAP supervision and KLAP monitor. That's number one. And all of those requirements that KLAP would want, whether it's going to the resiliency group, whether it's going to therapy, whatever they suggest, whatever that group suggests, I'm always in favor of. I think anytime anybody comes back into practice when they've had this type of problem, they need a practice monitor or a practice supervisor. And that supervisor should check out contracts to make sure there is a contract, to make sure that she's limited. My theory is, and I don't speak for my client, she should not be doing any family law. I think that's the death knell. I think she should be limited in practice to things like criminal work, traffic work, anything that her practice monitor, practice supervisor would like her to do. I think he or she should be able to audit her practice, to check on contracts, to be able to get into the trust account, to make sure that there is a trust account accounting all the time. He or she should also be able to meet with the KLAP people. There should be a release of information for the supervisor and KLAP to be able to speak with the therapist, the resiliency facilitator, and also to check about monitoring the drug or use of medication. What happens a lot, I always worry, is that someone doesn't take the medication. It scares me to death. And once you've been identified, so many people take themselves off the Ritalin or whatever the medication that you're using is. I can't remember what it is. They take themselves off. I think there should be only off the medication with the permission of a physician in discussion with KLAP and the practice supervisor. I think if you put all of those in practice, I think that she'll be okay when and if she's allowed to come back and practice law. I hope I answered that question.
It is generally not up to us to say how a lawyer should practice their craft, but the point that Justice Biles made, or at least the question he asked about the solo practice, it seems like your practice is very isolated.
And I will never do that again.
That's, and I don't know if we would direct a concern about that or
And I think
how
you
to do
should.
that, but that's certainly a caveat I would have. It's just the isolation that results from what you were doing before promotes the kind of.
And this is directed at you, Mr. Justice. You're going to pry that bottle out of my cold dead hands. I'm telling you, it's.
You mean medication?
Yes, the medication. It's a lifesaver, and I've had family members who have been on asthma drugs and have thought, "Oh, I'm fine now. I can go off of them," and I see the results. So that is not something you're going to have to worry about. I have no problem with it being checked on, but just for your peace of mind, those are lifesavers.
Any more questions? Thank you. I reserve 2 minutes for rebuttal.
Just a couple of quick things. Justice Biles, the letter I made reference to is Respondent's Exhibit A. It's from the psychologist. It's in case DA 11,793. It's a December 31st, 2013 letter from her psychologist. I think you brought up a really good point. I think it would be good to give the reinstatement panel some direction about the issue of whether or not supervision is appropriate, and if so, to what extent should that supervision occur. I think that would be excellent. I remember as I was sitting there listening to that I think it was in Craig Collins' disciplinary case, you suspended Mr. Collins for a year, but you said when there's a reinstatement hearing, these issues should be addressed by the reinstatement panel. I think that would be very helpful to direct the reinstatement hearing panel to what issues you think are important.
Anything further for presentation?
No, sir.
Any more questions? Thank you, counsel.
Thank you.
Thank you all for your statements this morning and this afternoon. Court will take this matter under advisement.